dual classification of the reserve 1105 Kaituna. Very extensive recommendation here. Would someone like to move the recommendation so that we've got that? Glenn, and seconded by Phil.
And
Glenn.
I convene it. Thank you, Leanne. I wonder if our staff could come up just so whether you have any. It's more a process matter, I think.
Yep.
But in case any questions arise.
Yep.
Do you have Robert O'Connor, Lewis Byrne, and Joanne Walton that
Yep.
resource the panel? So you'll see the information there. Obviously, there's a lot of history involved with this. As I've just said, this really is more a process question where the panel report is asking the council to start again due to the original narrow wording which did not permit objections, and 2 objections were received in beginning this process. There are many issues there, many layers. As far as the huts go, that proposal there is to actually put them on a secure legal footing. And once we go down the path of a management plan, that could well throw up a different time frame over that at least. For instance, coming out of an assessment of heritage values. There's a lot more I could say there, but you know, I really have to hope that you've read the report. There's a lot of history, how this matter has really gone from council to council to council, and that we've inherited it and that we have to try and find a way forward. And obviously we want us to, I think we need to act reasonably. There are, you know, there's certain attachment to the land. There are obviously some legal considerations, public-private debate, etc. So, but these are the experts.
Yeah. Paul and then Andrew.
I just want to ask a question. We've made some decisions around Taylor's Mistake, Boulder Bay and the Mary Gardens, and I just want to make sure that with those decisions we've got to be, do we have to be consistent with the way we treat this here in light of those decisions already made around this Taylor's Mistake, Mary Gardens and Boulder Bay?
Consistency would be desirable, but each individual reserve should be looked at individually.
My reading is that the Taylor's Mistake was more of a situation of legal road. This is actually a parcel of land that is a reserve. So without an in-depth knowledge of the other issues, that would be my initial thought on that.
Yeah. Andrew?
Thank you. My immediate concern with this probably relates the most to paragraph 2.4, sorry, 2.5. The leases be granted to the hut holders for a period of up to 5 years with no right of renewal. Now, given that the hearings panel is to be reconvened and the process is essentially to start again, if I was one of the hut owners, I would be concerned by the content of paragraph 2.5. Clearly the things that the panel will be considering once reconvened are matters of historic and heritage value and the current use of that land, alongside any cultural considerations and any other matters. It would be wrong to suggest anything about the outcome from that hearings panel because that's a matter for the panel, but in terms of the effect of the outcome of the hearings on the content of 2.5, the 5-year non-renewable lease, is it possible that that could then be quite different as a result of the deliberations and outcome of the hearings panel?
That's my understanding. I will defer to the team, but that this is an interim measure, and without wanting to second guess, it's always not wise to second guess, but that could well change coming out of the management plan process.
Councillor Livingston's correct. As I understand it, the hearings panel intended that the classification, the dual classification, was on an interim basis, so that a time could be taken to complete a full Reserves Act management plan. That Reserves Act management plan would produce the permanent solution. And so the leases granted in the interim would be for a short period. There's a second aspect to the period of the lease also, in that the Reserves Act only permits leases of up to 5 years for these types of the parcels of land. So those two reasons why that that short period of time was recorded there for the lease terms.
So I'm assuming that we're expecting this matter to be resolved permanently within that 5-year period.
Exactly.
Yeah, great. So if I was to take the attitude that what we're dealing with today is a matter of process and any issues of substance would be dealt with when the final recommendation of the hearing panel comes back, that would be a good approach?
Yeah.
Great, thank you.
So,
Excellent. Pauline.
therefore, do we really need that with no right of renewal in there?
Well, it's just to make clear that it is a short-term process, and a long-term solution will emerge from the Reserves Management Act, Reserve Management Plan process. So it's just to make it clear.
I know, but it's a message, isn't it, going out there? And so these people have been there for generations.
Yeah,
And
I mean,
5 years is a short time period.
This was a particular desire of one of the members of the hearings panel that a short period be given and that the permanent solution be dealt with through the management plan process later. And that the permanent solution may well offer a longer form of tenure, although as I alluded to in my answer to Councillor Turner, the Reserves Act will only ever allow us to grant 5-year leases.
Yes, I know,
And
that's
so
not what I'm questioning, it's the
even the permanent solution, which may allow batches to be present on the long term, at the next level down, we will only ever be able to grant 5-year leases
understand that.
each time.
Does that have to be there? May I ask? Does that have to be there? Is that a requirement of the Act that you have to be that explicit and have in brackets with no right of renewal?
I think it's there for information,
Okay.
to make it clear that batch owners are not going to get 50-year leases.
Yes, but it doesn't mean that they won't get a right of renewal. They won't. Sorry, that doesn't mean they won't be able to renew their lease should the hearings panel decide.
Yeah, but
to
we're
go that way.
delegating authority to the property consultancy manager to grant leases to the hut holders for a period of up to 5 years with no right of renewal. So what we're delegating to the council property consultancy manager is just this ability. So, I mean, it's just making it clear that person can't put in a right of renewal, that it's another process to go through, I think is...
That's a fair point.
Yep.
So if the hearings panel came to the view that perhaps it would be all right for them to stay on for another 5 or 10 or whatever, who knows?
It would have to come back.
Would that stop them from doing it because they have no right of renewal?
They'd have to come back anyway, because this is only a interim step.
Okay, all right.
This just puts the deed to licence to occupy, is that the correct term, has actually expired, so this puts them on a legal...
This will put on an interim basis the batches on a legal, their occupancy on a legal basis, which they don't have at the moment.
Yeah, they're illegally occupied.
Yeah.
Can I just perhaps add that under the current licences they have an expectation to take their tenancy out till 2020. So by actually going through this process, if we do, and then issue leases as we're allowed to do under the Reserves Act for a period of 5 years, we're giving them what they would have currently.
All right. Thank you. I'll put the motion. All those in favour say aye. Aye. As opposed say no. It's carried. Item